A speeding driver runs a red light on a wet intersection and strikes a driver who is not wearing a seatbelt. Moments later, a bystander drags the victim from the wreckage, worsening a spinal injury. At the hospital, a doctor administers a medication without checking the chart, triggering a severe allergic reaction. We have a claimant with multiple injuries and 3 separate parties who acted carelessly. To resolve this, we must isolate exactly which party is financially responsible for which specific harm. Proving these parties owed a duty of care and breached it is only the first step. Without successfully mapping a definitive chain of causation through this chaos, the claimant recovers nothing. Establishing legal causation requires passing through 3 distinct conceptual filters: factual causation, intervening acts, and remoteness. Factual causation requires proof of historical reality. Did the defendant's exact breach physically trigger the harm? The second filter tests for unbroken continuity, determining if a Novus Actus Interveniens, a new intervening act, severed that connection. The third gate, remoteness of damage, requires the damage suffered was a reasonably foreseeable consequence of the breach. Successful legal analysis requires keeping these steps separate. Merging factual causation with legal foreseeability is a common mistake that leads to an incorrect conclusion. Factual causation begins with the but-for test. We ask, but for the defendant's negligence, would the harm to the claimant have occurred? The case of Barnett v. Chelsea and Kensington Hospital illustrates this rule. 3 night watchmen drank tea laced with arsenic and went to a hospital casualty department. A doctor negligently refused to examine them and sent them home. One of the men died later that day. While the hospital breached its duty, medical evidence showed the arsenic poisoning was already so advanced that even with immediate treatment, the patient would have died. The claim failed because the hospital did not cause the death. If the claimant would have suffered the same harm regardless of the defendant's mistake, there is no factual causation. The but-for test is difficult to apply in industrial environments, where claimants suffer diseases caused by multiple, overlapping sources of exposure. In Bonington Castings Ltd v. Wardlaw, an employee contracted a lung disease from inhaling silica dust. Some dust came from pneumatic hammers, for which the employer was not in breach. Another portion came from swing grinders, which the employer had negligently failed to maintain. Because science could not isolate which specific dust particle triggered the disease, the House of Lords applied a modified test. The claimants succeed are showing the guilty dust from the employer's breach materially contributed to the disease. Contrast this with Wilshire v. Essex Area Health Authority, where a premature baby went blind. The hospital's negligence was only one of 5 distinct possible causes. Because the risks were alternative rather than cumulative, the claimant could not prove the defendant's breach caused the harm. These scientific limits are most apparent in mesothelioma cases. This fatal cancer is triggered by asbestos fibers, but there is no way to prove which specific exposure over a long career was the fatal trigger. To resolve this, Section 3 of the Compensation Act 2006 imposes joint and several liability. If a claimant can show an employer materially increased the risk of mesothelioma, that employer is liable. This allows the claimant to recover full damages from any one negligent employer. Under the Civil Liability Contribution Act 1978, the defendants must then settle the apportionment of that cost among themselves. When standard logic is limited by the current state of science, the court uses these specific exceptions to ensure victims are compensated. Once a factual link exists, we move to the second gate. A Novus Actus Interveniens is an event so independent that it breaks the chain of causation and absorbs the legal liability. In Knightley v. Johns, a defendant blocked a tunnel through negligent driving. A police inspector then gave an unforeseeable negligent order for a constable to drive against traffic. That order broke the chain. However, in Rouse v. Squires, a driver who blocked a road remained liable when a second driver crashed into the scene. Other drivers failing to see a hazard is a foreseeable consequence of blocking a highway. The claimant's own actions can also break the chain. In McCabe v. Holland, a claimant with a weakened leg chose to descend a steep staircase with no handrail. The court ruled this act was entirely unreasonable and broke the chain of causation between the original injury and the new fall. A defendant is liable for the natural, foreseeable consequences of their breach, but they are not responsible for subsequent independent recklessness. The final gate is remoteness. As established in the Wagon Mound No. 1, a defendant is only liable for damage of a kind that a reasonable person would have foreseen. Under the similar in type rule from Hughes v. Lord Advocate, a child was burned by an unpredictable lamp explosion. Because injury by burning was foreseeable, the defendant was liable even though the exact way the fire started was not. The second proviso is the eggshell skull rule. In Robinson v. Post Office, a minor injury led to a severe allergic reaction to a medical injection. Because medical treatment was a foreseeable consequence of the injury, the defendant was liable for the full extent of the reaction. Remoteness requires the type of harm to be foreseeable. Once that is established, the defendant is liable for the full extent of that harm, regardless of how severe it is. Once the claimant proves duty, breach, and causation, the burden of proof shifts to the defendant to establish a defense. Volenti non fit injuria is the voluntary assumption of risk. The defendant must prove the claimant had full knowledge of the risk and freely consented to it. Legally, knowing a risk exists is not the same as consenting to it. In Morris v. Murray, a claimant flew in a light aircraft with a pilot he knew was heavily intoxicated. The drunkenness was so extreme that the court ruled the claimant had implicitly accepted the risk. Rescuers are treated differently. In Haynes v. Harwood, an officer stopping runaway horses was not volenti. He acted under a moral and social duty to save lives, which is not a truly voluntary choice. Because these defenses prevent any recovery at all, the legal threshold for establishing them is high. The Law Reform Contributory Negligence Act 1945 allows the court to reduce damages if the claimant was also at fault. In Froome v. Butcher, the court asked if the claimant failed to take reasonable care for their own safety. Froome set the standard for seatbelt cases. If wearing the belt would have prevented the injuries, damages are reduced by 25%. If the belt would have only made them less severe, the reduction is 15%. Contributory negligence applies when the claimant's carelessness contributes to the damage, even if they did not cause the accident. This mechanism allows the court to apportion responsibility between the parties and adjust the compensation accordingly. When analyzing a claimant's behavior, avoid confusing a Novus Actus Interveniens with contributory negligence. If the claimant was simply careless, use contributory negligence to reduce their damages. Reserve Novus Actus Interveniens for claimant actions that are entirely unreasonable and unforeseeable. Precision in separating the tripartite filters from the defensive toolkit ensures the negligence analysis is complete and accurate.